Yes.
So do you want the matter to start afresh or what? I should send the file back to Lagos.
I think that would be a more tidy arrangement. Because we have to, that amendment, if it can be taken virtually, we have no issue, my lord.
No, I was thinking of taking it back to Lagos to start afresh, isn't it? But what do you say?
So that will take time.
That will take time if we are to start it de novo. But if we allow the amendment to take place, then we can take the rest of the proceedings virtually. I think it will be okay.
After the amendment, what will happen? You still recall your witness to testify?
Yes, my lord.
It's okay. Okay, it's okay. You'll discuss that with Adia later. Let's get to the business of the day.
My lord.
Adia.
Yes, my lord.
This Atlantic something is for judgment. Are we ready?
Atlantic shrimpers.
Yes, it's for judgment.
I don't even know the council, so I don't know whether they are here. I did not inform them.
I told you that it's for judgment now.
My lord, maybe my mind skipped it. So that's
okay. What you do by is to tell them that I will do it by 4.
Okay. I will look for that. Number, and I don't have it on this phone. I don't have their particulars on the phone, but I will check. Check and get back to them.
Okay, I will send you the.
Okay, sir.
Then there is this Uyo matter. I don't know whether.
Let's do Lagos matter before Uyo.
It's for ruling. It's for ruling.
We senior Uyo matter.
It's for ruling.
Okay, my lord.
I don't know whether they are online.
Yes, my lord, I'm here.
Okay, Mr.
Benedict, my lord.
Benedict,
yes, my lord.
For who? For the claim?
That is in 45 to 20. Yes, my lord. I'm for the claimants.
Okay.
I'm for the claimant, my lord.
Okay. What is absent, ba?
Yes, my lord.
Yes, my lord.
BM Nwegi, ba?
Yes, my lord. Yes, my lord.
For the claimant. Yes. What about Mr. Ekanem? No, he's not here.
My lord, the next part is Ekeminudin.
Ekemin, yes.
He's not here. Yes, Ekeminudin, my lord.
What about DD legal, Mr.
Jejerom Akpan?
Akpan is not also here.
Yes, my lord.
Okay. Just for ruling, let me deliver my short ruling. So, Mr. Ben, this is my ruling.
Yes, my lord.
This is a ruling in respect of notice of preliminary objection dated 11th of April 2022, but filed on the 13th of April 2022 by the first and second defendants praying the court for the following, and I quote, that there is currently pending before the Akwa Ibom State High Court, ACN Udim Division, a suit involving the same parties and arising from the same event, namely, the defection of the claimants from the party that elected them to another political party before the expiration of the tenure for which they were elected to serve as councillors, for which reason the subsequent filing of this suit, while the suit in ACN Udim Division is yet to be determined, amounts to abuse of judicial process. Take further notice that at the hearing of this application, counsel shall urge the court to strike out this suit in limine on court. The grounds upon which the application raised are follows. Number one, the determination of whether the claimants are entitled to be paid the claim salary allowances is dependent on the determination of whether their seats did not become vacant following their defection from the political party that elected them as councillors to another political party before the expiration of their term. Number two, this honorable court has no jurisdiction to determine the justiciability or otherwise of defection by elected representatives from one political party to another. Number three, it is the Akwa Ibom State High Court sitting in ACN Udim, which has the jurisdiction to determine the issue of law in ground 2 above, and since the claimant's entitlement to salaries and allowances depends substantially on the determination of their status by the said High Court, and being that the claimants already have a suit on the subject pending at the State High Court, the suit before this court by the same claimants against the same defendants ought to be struck out on court. The objection is supported by a 12-paragraph affidavit deposed to by one Eden Inyong, a staff of a law firm of the counsel for the first and second defendant. Also filed was a written address accompanying the objection, wherein counsel to the first and second defendant formulates a loan issue for determination to it. And I quote, whether this suit is not an abuse of court process in view of the pendency of suit number HEU/1/2019 at the ACN Udim Division of Akwa Ibom State High Court, and whether this court can determine this suit without stepping out the jurisdictional boundaries of this court on court. Counsel contends that the claimant in this suit are asking for payment of accrued and outstanding salaries and allowances, which allegedly accrued to them as councillors representing the respective wards in ACN Udim local government area of Akwa Ibom State. Counsel continued that upon their defection from PDP to APC before the expiration of the tenure for which they were elected, the claimants lost their seats by operation of law in the ACN Udim Legislative House, for which reason they are no more entitled to receive salaries and allowances. Counsel submitted from the above that some serious issues have arisen, namely, whether the claimants had indeed defected from one party to another before the expiration of their tenure, and if the answer is in the affirmative, what's the legal consequences of the defection? That if the claimants had indeed defected and the legal consequences applied, the claimants would not be entitled to receive salaries and allowances. Counsel also submitted that the fundamental questions above ought to be resolved first before the resolution of the question of whether this court can make an order of the payment of the monies claimed by them as salaries and allowances in this suit. The questions are political questions rooted in substantive law to which this court has no jurisdiction to delve into. The question of whether the seat of an elected legislator is vacant or not is a question reserved for the High Court to the exclusion of all other courts. Counsel maintained that it would have been a different issue if the tenure of the claimants as councillor had been challenged. In such situation, this court would have no difficulty adjudicating on the issue at the claimants' alleged accrued salaries and allowances. But in this case, the defendants are saying that the claimants had voluntarily abandoned their seats and were thus not entitled anymore to receive salaries and allowances, with the issue have to be determined first, and this court has no virus to determine such issues. Counsel submitted further that this suit is thus hasty, premature, and yet to ripen into a course of action for the National Industrial Court of Nigeria, namely recovery of salaries and allowances by former political office holders. Counsel argued that though the parties have been smartly juggled, but the identities of the parties remain the same, it is still about the same seats, and both seats seek to establish the entitlement of the claimant to prerequisite of political power offices. Counsel posited that the common feature of abuse of court process is the improper use of the judicial process to interfere with the due administration of justice, as exemplified in filing multiplicity of action on the same subject matter. Counsel cited the case of Oga and Igbe. Counsel continued that in all cases of judicial or court processes, the bottom line is that the process of a court has not been used bona fide. In the case of multiplicity of a suit, the subsequent suit is prima facie executive and oppressive. That the abuse lies in the multiplicity of suit or action rather than the exercise of that right. That an abuse may be constituted through a proper legitimate conduct in bringing action, even in the exercise of an established right in the manner or time of instituting actions. It may also be constituted by irregularities in the pursuit of action, such in the case of Ships and Muzaras, Unwansu and PDP. To the further contention of a counsel that Foreign National Industrial Court can make a decision as to the claimant's entitlement to salary, the State High Court must first determine whether the claimants did not lose their seat as councillors in the ACN Udim Local Government Legislative House following their defection from the PDP to APC midway in their tenure. That the claim for payment of the salaries and allowances must necessarily await the decision of the High Court on the matter. Counsel concluded that this suit is an abuse of court process and ought to be struck out, that the rules of this honorable court allow the court to strike out any matter at any stage of the proceedings before conclusion of the trial, before where the striking out becomes expedient. Claimants reply on points of law. A reply, counsel to the claimants adopted the law issue for termination raised by the first and second defense. Namely, counsel submitted claims without arguments and has not in our jurisprudence. Maybe somebody's computer is making noise. Counsel also submitted that making a comparative analysis of claims and defense of parties as yardstick for the termination of the jurisdiction of the court is not a proper approach. Counsel further submitted that in determining whether or not a court has jurisdiction to entertain an action, it is the claimant's originating process, that is the writ of summons or settlement of a claim as the case may be, that has to be considered. Counsel cited the case of Okorocha and United Bank for Africa, Orthopedic Hospital Management Board and Garba, AGF, and AG Abia State. Counsel reiterated that the claims of the claimants are for the payment of their accrued and outstanding salaries, allowances, and other entitlements as counsellors. That the first and second defendants are not in doubt as to the claims of the claimant, as same has been emphatically pointed out by their claim in their by their counsel in their written address in support of their application. Counsel stated that the claims of the claimants or issue of payment of salaries and entitlement of public officers, such as that of the claimant in this case, are well within the jurisdictional competence of this court to hear and determine. A defense by an opposing party remains a defense, and for whatever purpose, it may serve as a defense and can never be considered in deciding the decision of any court whatsoever. And whether the claims of the claimants in the alleged Exhibit A are the same with that of this present suit, and thus consider an abuse of court process, counsel contended that Exhibit A, being a public document, falls short of the requirement of the Evidence Act, that the law is clear that the only secondary evidence admissible with respect to a public document is a certified true copy of the document, and no other kind of secondary evidence. Counsel started the case of Oburu and Uduagan, Araka and Egbu. Counsel added that when a document is a public document, only certified true copy is admissible within the meaning of Section 90, sub 1C of the Evidence Act, and no other kind of secondary evidence is admissible, citing the case of Godwill and Trust Investment and Ume. that the attached Exhibit A is a court process and therefore a public document within the meaning of Section 102 of the Evidence Act. It's only certified true copy of same that will suffice. Photocopy of the court process is not sufficient proof of the existence or pendency of alleged suit. So the further contention of a counsel that, granted, though not conceding to the fact that Exhibit A attached to the affidavit in support of the objection were to be properly or duly certified, the relief on counterclaim are different from the claimant's claims in this suit, and the parties in Exhibit A are radically different and very distinguishable from the parties in the present suit. In conclusion, counsel argued that this application is lacking in substance and merit, brought in bad faith, intending to punish the claimant, and further waste the valuable time and energy of this court, and therefore liable to be struck out with punitive cost of 200,000 naira in favor of the claimant. Counsel urged the court to so hold. First and second defendants' rejoinder on points of law. Counsel submitted that Exhibit A forms part of an affidavit, and a document so attached to an affidavit can rightly be relied upon by the court in the determination of the application placed before the court. Counsel relied on the dictum of Justice Mary Odili, as he then was in the case of Ezechukwu and Onwuka, where it was held that all documents attached to an affidavit form part of the affidavit in question, and it's not possible to raise objection to its admissibility. Counsel urged the court to discountenance the submission of counsel and of counsel for the claimant and deem Exhibit A as properly placed before the court. Counsel contended the submission of learned counsel to the claimants that the court can only look at the relief sought in this court to determine whether it has jurisdiction to entertain a suit or not is incorrect, that the law allows the court to look beyond the relief, where doing so will assist the court in arriving at substantial justice. Counsel referred to the case of Futo and Amcon. Counsel reiterated that the court can rightly look beyond the relief in the suit before this court and look into the relief in the suit in the High Court and look at the averment in the two suits. Counsel urged the court to strike out this suit. My opinion, I have considered the notice of preliminary objection and the reply of the claimant as well as other processes filed in this suit. Having also considered the submission of parties, the point I will consider is whether the objection has merit. To the submission of a counsel for the first and second defendant applicants that this suit be struck out in its entirety for being an abuse of court process arising from multiplicity of suit. To the claimants, to the applicant, a cursory look at the claimant's suit in suit number HEU/1/2019 is an exact replication of the claimant's action in the instance suit, as it has similar facts and claims. Claimants in reaction to the applicant's notice of preliminary objection submitted that the instance suit is not the same with suit number HEU/1/2019 and urged the court to strike out the applicant's objection. The background of this case is that an action was instituted before the High Court of Eastern Odim Division in suit number HEU/1/2019 by Honorable Peter Udo, Honorable Boniface Inyan, and People's Democratic Party against the present claimants, praying the court to declare the seat of the claimants vacant. The claimants then, as defendant counterclaimants, counterclaim and ask for a declaration that their expulsion from the party was in breach of the law and therefore does not amount to defection within the purview of the law. The suit which sought the order of court to declare the claimant's seats vacant as councillors of the respective wards was withdrawn and accordingly struck out by the court, leaving behind the counterclaim. In Chief Victor Ume and Maurice Ew, the Supreme Court per Onege, as he then was, held that, and I quote, "It is settled law that for there to be an abuse of court process, there must exist a multiplicity of suits between the same parties on the same subject matter and on the same issues, which preconditions are mutually inclusive at their conjunctive. In the case of Saraki and Kotwe, this court held inter alia that, and I quote, the employment of judicial process It's only regarded generally as an abuse where a party improperly uses the issue of the judicial process to irritation and annoyance of its opponent and the efficient and effective administration of justice. This will arise in instituting a multiplicity of action on the same subject matter against the same opponents on the same issue. The abuse lies in the multiplicity and manner of the exercise of the right, rather than the exercise of the right per se. The abuse consists in the intention, purpose, and aim of the person exercising the right to harass, irritate, and annoy the adversary and interfere with the administration of justice on court. Generally, abuse of process contemplates multiplicity of suit between the same parties in regard to the same subject matter and on the same issues. The bottom line, therefore, in regard to abuse is that to institute action during the pendency of another suit claiming the same relief is an abuse of court process. And the only course open to the court is to put an end to the suit. It does not matter whether the suit is an appeal. The subsequent action will constitute an abuse of court process. Abuse of court process, therefore, simply in practical sense, denotes a situation where a party has instituted a multiplicity of suit against the same issues. This manner of using court processes as obviously lacking is bona fide, leads to the irritation and annoyance of the other party and thus impending due administration of justice. See the case of Okafor and Attorney General of Anambra State. In determining the instant application in the light of the above decided judicial principles, it is pertinent to compare the claims of the claimant in suit number HEU 119 and instant suit in NICN/UI/46/2022. The defendant /counter claimant in suit number HEU/2019 claim against the defendant as follows. And I quote, whereof the defendant's counterclaim as follows. A declaration that the expulsion of the defendant/counterclaimants was in breach of the law and therefore does not amount to reflection within the purview of the law. Number B, general damages in the sum of 200 million naira. Number C, exemplary damage in the sum of 300 million naira only, unquote. While in the instance suit NICN/US/2022, the claimants claimed against the defendant thus, and I quote, wherefore, the claimants claim against the defendant as follows. A declaration that the claimants are entitled to be paid their outstanding salaries from February 2019 to August 2022, and a refusal by the defendant to pay same is illegal and unlawful. B, an order directing the defendant to pay all outstanding salaries and other entitlements accruing to all the claimants from February 2019 to August 2020, impressed from December 2017 to August 2020, amounting to the tune of 86 million naira 91 kobo, most appropriately particularized as follows. Number C, an order restraining the defendant from interfering with exercise of lawful duties imposed by law on the claimants serving the respective terms as leader and members of the ASEAN Odu Local Government Legislative Council. Cost of action assessed at 10%, 10 million naira only, unquote. To sustain an application for abuse of court process as in the instance suit, there must coexist inter alia. Number one, a multiplicity of suit. Number two, between the same opponents. And number three, on the same subject matter. And number four, on the same issues. A critical examination of the two suits shows that the defendant/counterclaimant in suit number HEU1/2019 are the claimant in the instance suit, while the claimant in suit number HEU/1/2019 are not the same as the defendant in the instance suit. The relief sought in the counterclaim in suit number HEU/1/2019, which is a declaration that the expulsion was in breach of the law, is different from the reliefs sought in the instance suit, as set out in the claimant's amended statement of fact filed on 11th of December 2024, which are basically for their salaries and entitlements. Therefore, it is my respectful view that the first and second defendants have not established that the two suits filed by the claimants amount to multiplicity of suit. It's not also shown that the two suits are between the same opponents, on the same subject matter, and on the same issues. Overall, I find no merit in the first and second defendants' objection. It therefore fails and is accordingly dismissed.
Please.
Hello, we are grateful for That's well considered.
Thank you. Mr. Ben, we adjourn?
Yes, my lord.
For
For hearing, my lord.
okay. So, Mr. Ben, which date is Mr. Okon around?
I've not seen her online.
Which date, Mr. Ngwe?
I always may be accommodated on the 9th of October.
No, it's not convenient, Mr.
The copy.
Let's get to. It's like I understand that Mr. Kimini has some other matters. His matters are adjourned to November.
No, we're only looking at the age of the case.
Yes, now it's in my fault. I also inherited it, didn't it?
I don't know if we can have indications. We don't know the dates his matters were adjourned in November.
Or should we just just say that the convenient date will be communicated to council? Yes. How do you say? What do you say?
That would be okay for us.
Or should just adjourn it to any date?
Yes, my lord. My lord, the date in October will also be convenient for us.
So which date in November?
About 3rd November.
No, we should avoid the from 3rd to 9th. I may not be around.
About 12th of November.
Okay. 12th is which day?
It's a Wednesday.
Okay. So, given the circumstance, cases are adjourned to 12th of November 2025 for hearing. Hearing notice shall be issued and served on all the defendants. Thank you. Aja.
Yes, sir.
Okay, which one again?
The file is with your lordship.
No, I mean we have the CBN case. We have
the CBN case. We have it.
Okay, Mr. Polly, you are in the CBN case?
Yes, my lord.
Okay. We have Omota Yogania. We have Paul Agu. We have
We have
flour mills.
flour mills. Yes, my lord. Yes, my lord. My lord, I've sent message to
The claimant.
the councils in Atlantic, both of them in Atlantic Shrimpers. But
Okay,
I said 4 o'clock. Are we going to use this same Zoom link?
yes.
Okay, that's what I sent to them.
Okay, thank you. Yes, Mr. Okay, CBN and okay, Mr. Ume and CBN.
Yes.
Parties absent or present?
Then the claimant should be here.
He's in court? He has
yes,
joined.
my lord.
So claimant present.
Well, I can't see him.
Huh?
I can't see the claimant. Sir. At least he can signify his hand if he's online.
Well, I think we can go ahead because I gave him.
Okay, yes. What about the
link.
defendant?
Well, the defendant is absent.
Eh?
The defendant is absent.
Okay, absent. Yes, appearance.
Yeah, respectfully, my lord.
Yes.
Paul Omonjade for the claimant, and appearing with me is Stephanie Ukonga Ojekere.
Okay.
Good morning, my lord.
Stephanie, good morning. How are you?
Fine, thank you, my lord.
How's Lagos?
Very well, thank you.
Well done. You're welcome on board. Steph.
May you please discuss?
Yes.
E.G. Jeffrey.
E.
G. Jeffrey.
Jeffrey, yes.
Yes. Spelled as Geoffrey. My appearance is for the defendant.
Okay, thank you.
Yes. So, my lord, we have motion for extension of time.
Okay.
Dated 16th December 2022. We've filed and served the claimants.
The matter is for adoption of final written address.
Yes,
but
yes, my lord.
We have filed an application
to regularize our.
Yes, to regularize our final written address. Mr.
Yes.
Paul, no objection to the application?
No objection, my lord.
Okay, Mr. Jeffrey.
Yes, my lord.
The application is dated and filed.
Dated and filed 16th December 2022.
Okay. Yes.
Subject to the convenience of this honorable courts with 6 terms.
Okay, thank you. So defendant's application for extension of time to file is final written address dated and filed on the 16th of December 2022 is granted as read.
Of
The
course.
cop please.
Yes, Mr. Jeffrey.
Yes, my lord. My lord, we also filed, just out of abundance of caution, a motion for extension of time for our reply address, but I don't think it will be necessary to move it since our motion for extension of time for the final written address is deemed properly filed and served today.
Yes, yes.
All right.
So that motion was filed when the motion was filed. I'll just start it out.
It was filed on the 21st day of March, my lord.
Okay.
2023, 21st of March, 2023, my lord.
File when?
21st day of March, 2023.
Okay. So you should withdraw it.
Yes, my lord. Wish to withdraw a motion dated and filed 21st day of March, 2023.
So the defendant's application for extension of time to file is reply to the claimant's final written address having been withdrawn is hereby struck out.
Record places.
The cop please.
Yes, Mr. Jeffrey, yes.
So, my lord, we have a final written address dated 16th December 2022.
Yes.
Date and filed on the same date.
Yes.
My lord, we seek to adopt our final written address as our oral argument in this suit in urging the court to dismiss the case of the claimant.
Yes. Yes, Mr.
Well, should I proceed to adopt our
Yes,
reply
yes,
address?
yes.
All right. Well, we have a reply address dated and filed the 21st day of March 2023.
Yes. Yes.
We seek to adopt it as our reply address, as our oral argument in this suit, in also urging the court to dismiss the case of the claimant.
Okay, thank you.
Most grateful, my lord.
Thank you. Yes, Mr. Paul.
Yes, my lord. The claimant's final written address is dated 30th of January 2023 and filed is 2023,
Okay.
30th January 2023.
Yes.
And filed the same date, my lord.
Yes.
We seek to adopt it as our argument in this matter. My lord,
Yes.
by way of adumbration,
Yes.
we want to say the following.
Yes.
The claimant was dismissed as per the dismissal letter for gross misconduct.
Yes.
And the defense witnesses, the
Yes.
two defense witnesses in paragraph 12 of their statement of oath
Yes.
told the court that the claimant
Yes.
refused to present himself for surgery.
Yes.
My lord, the evidence before the court,
He refused
the
to present.
evidence before the court, my lord,
Yes.
indicate that the claimant was involved in an auto accident on the 21st of January, 2017.
Yes.
He was thereafter moved to the bank's, the CBN hospital, where he was subsequently referred to Emel Hospital in Lagos.
Yes.
Emel Hospital subsequently wrote the defendant for approval to carry out surgery on the claimant, my lord. That approval, my lord, was only brought to the attention of the claimant on the 5th of July, 2017, when he went to visit the clinic.
Yes.
Before then, my lord, he has resorted to traditional bone setters services to heal the bone that was fractured, my lord.
Yes.
The question that readily comes for asking, my lord,
Yes.
is whether the claimant willingly, deliberately refused to subject himself to medical surgery.
Yes.
The answer, my lord, is in the negative, because an accident took place on the 21st of January 2017, and notification of approval to conduct the surgery was only communicated to the claimant in June of 2007, by which time the claimant had already resorted to traditional bone setters to deal with the compound fracture, my lord.
Yes.
My lord, the the disciplinary committee report, Lord,
Yes.
indicates there was testimony, particularly at pages 14 to 15, by the medical director of the defendants disciplinary committee, my lord. Yes, my
Mr.
lord.
Paul,
Yes, my lord.
what was the claimant dismissed for?
He was dismissed for gross misconduct as per the dismissal letter, my lord. But in the statement on oath, the defendants specifically
Yes.
indicate in paragraph that is for malignant.
He was dismissed for what?
Malignant. That is for deliberate absence from work, my lord.
Okay.
And
he was issued. He was issued
queries. He was issued queries, my lord. 2 queries.
Yes, and he participated in the disciplinary proceedings.
Yes, he participated, my lord.
Yes, so what is your grievance?
Yeah, the grievance, for example, 1, the reason for the dismissal that the claimant was absent from work without backing up his absence with medical reports is not supported by the evidence before this court, my lord. Exhibit SU14.
Yes.
Those are the medical report, exhibit 14, I to F.
Yes.
Indicate that there are various medical reports. And furthermore, my lord,
116.
there is the letter from the defendant's hospital that refers.
Mr. Paul, in order not to, because you are trying to review the, you are muted.
My lord.
Mr. Paul.
My lord.
Mr.
Yes.
Paul. You know,
yes,
you have them file your final written address, isn't it? You are muted. Mr. Paul, you are muted. Hey, Mr. Paul.
Yes, my lord.
Mr. Paul, yes, instead of trying to re-argue and you understand and repeat what you have said in your final written address. Hello. Yes, you are muted.
It's okay, my lord.
What I'm trying to say is that instead of trying to re-argue and repeat what you have already stated, because you have already filed your final written address, I think that
yes, my lord.
So the fact of the case is there, your submissions are there, everything, your arguments are there, isn't it? I even thought
yes, my lord,
that you want to, one gray area that you want to hammer on. But to start to review what you have already submitted, I don't think it will.
It's okay, my lord. Well, in the final submission, my lord, the evidence before the court do not support the case of malignant.
What?
And
okay. In
does
the
not support the case of malignant. They are already in evidence, the medical report, the disciplinary committee report, particularly the testimony in paragraph pages 14 to 15.
It says what?
Of the LG with the fellow. So
what did they say? What did the disciplinary report say?
The disciplinary report,
Yes.
strictly speaking, agree with the submission of the CBN that the claimant was absent from work without cause.
Yes.
But my lord,
yes,
the report of the disciplinary committee cannot be in vacuum. It had to take its root from the evidence and testimony before it.
Yes, but then is there any evidence? Is there any evidence presented by the claimant that his his absence what with the defendant's permission, or that his absence was justified?
Yes, they are there, my lord. The medical reports are all there, my lord. They are in evidence, my lord.
But did he inform the defendant that he was going to be absent? It's not just the medical report indicating that somebody is absent.
Hello, my lord.
Yes, I can hear you. What I'm trying
the defendant at various points in our
Well, I think if I may, my lord, our processes are ready before my lord, and
yes.
I have the claimant to
initially to Calabar was cancelled, and he was asked to remain in the office in Lagos when he continued with his treatment, my lord. So we extensively.
What I'm trying to ask is, Mr. Paul, what I'm trying to ask is, when the claimant was absent, did he seek the permission of the defendant? Was the defendant aware that he was going to be absent?
He was aware. The defendant was aware.
Oh, and
he was aware, my lord.
And it gave approval of his absence.
He was while he was on that leave, he was in a medical leave, my lord. He was even he was on medical leave. Thereafter, he was sent on annual leave.
Mr. Paul.
Yes, my lord.
Even if somebody was going, on a medical leave, he still has to seek for the permission of the. He did.
Knowledge of the defendant, my lord. We have demonstrated that in our.
He asked for that permission.
He did, my lord.
And it was granted. And it was granted.
My lord, yes, Lord. There are letters from the hospitals and the medical reports, my lord, which I read to earlier.
No letter from the hospital. When somebody when somebody was going for a medical leave, I thought he was supposed to write to his employer asking.
He did. He did, my lord.
And it was.
There was a letter.
And it was granted. It was approved.
My lord,
I said it was approved.
Yes, because he was referred to those when he was referred to the first hospital and thereafter to the.
No, what I'm trying to say is that, Mr. Paul, what I'm trying to ask is that when somebody is going for any leave, I thought that leave has to be approved. Okay.
Hello, my lord.
I can hear. Yes.
Yes. Yes, my lord.
What I'm trying to say is that when somebody is going for any leave, whether medical, casual, annual leave, or whatever, I thought he should write to his employer, who is expected to approve or disapprove the leave, isn't it?
Yes, my lord.
So what I'm trying to say is that
there was a leave. My lord, there was a leave given for the claimant to approval given for him to proceed on that leave, and we have equally stated in the final address the policy of the defendant with regard to extension of such a leave, and the burden or the responsibility for the extension is for the defendant to forward a form to the claimant through his last known address.
Okay.
Yes.
Okay. So okay. I'll go through the addresses.
And my lord,
yes.
why the claimant reported for duty and he was refused and resumption of work because his medical state had not been established. The defender hospital also referred him to the external medical facilities, and they also responded that the claimant was not fit to resume work. Those are all in evidence before the court.
And was it during that time that he was found to have absented himself from work? Was it during that time that he
yes,
was?
My lord. Yes, my lord.
He was referred by the. It was during that time.
By the. Yes, my lord.
It was during the time that he was referred to that hospital by the defendant that he was found to have absented himself from work.
Yes, inclusive of that period he was referred, my lord.
Okay, yes. So okay, I'll look at it. I'll look at it.
Yes, my lord. I'm most grateful.
Thank you.
So on that note, my lord, we urge the court to grant
the claimant's reliefs, huh? Okay, it's okay. It's okay. So
Actually, my lord, I had moved my reply on point of law, but so let me just leave it at that.
I've already addressed your reply on point of law, and you cannot have a second bite at
yes, I admit that. So I wouldn't. There are issues that I would have loved to clarify, but since everything is already before the court,
Mr. Jeffrey, what are those issues? Let me just hear you. I'm not recording anything, but let me just hear you. What are those issues that you want to?
So the issue is not just he got approval, and then the bank is not silly enough to grant somebody approval and then dismiss the person for for proceeding with that. right?
Yes.
And it's not just a dismissal, there was a committee set up to do that. So it, he got approval, but it elapsed.
Okay,
And there
okay,
was supposed to be extension. So
okay.
that was a factor. Then there was also issues around him not reporting to the appropriate place. He makes
No, but he wasn't dismissed based on that, isn't it?
he wasn't dismissed based on
Yes.
the approval, the one he got with approval.
No, he was just dismissed based on absence from duty, isn't it?
Yes, but not for the time frame he got approval.
The query given was with respect to his absence from duty. Disciplinary proceedings. Disciplinary proceedings conducted was also with regards to his absence from duty, isn't it? And so also the dismissal. Yes, also dismissal.
Yes.
But your main issue is that even though he was given an approval, but it lapsed, and after it lapsed, he didn't seek for extension.
There's a procedure for extension.
Okay.
There's a procedure, and he's a senior staff.
In the conditions of service.
Yes, and he's aware.
Okay, he didn't follow that procedure.
Yes.
Okay.
And then he was transferred to and supposed to report at a particular place. He didn't report there. So it's not. It is that he also that inclusive and his own.
But that one wasn't the basis for a dismissal, isn't it?
It was partly it. So
no. Okay, the grounds for the dismissal are too many.
No, my lord. So it's just that he did not show up to work, but he's not showing up to work is one. There are so many elements that are combined in it.
Yeah, but his reason was that he was absent on the ground of health and ill health.
Yes.
Isn't it on medical grounds?
Yes. And he was given approval for a duration.
Yes.
He did not get extension afterwards. That is one. Secondly, as part of being absent from work, he also was supposed to show up at the branch where he was transferred to. He didn't show up there.
Even though he wasn't fit to report, you are still expecting him to report, even though he wasn't well, but you are still expecting him to report.
No, but he wasn't. His medical leave had a duration.
Yes,
and it had not been extended.
Yes, after it. But what something that I want to ask is that after it expired, that is the approval given. Was he still not fit to report to office? In your investigation, did the panel investigate that after the expiration of the approval given to him for the medical leave? After that, when the panel for the did it find out? Did it find out whether after the expiration of the approval given for the leave, whether he was still fit to to report to office?
Let me not mislead the court. I have to confirm that. I'd have to go through that part of our process to confirm that.
So, it's okay.
I don't have this available.
It's okay. I'll look at the report of disciplinary disciplinary proceedings, whether the recommendation given to dismiss the claimant is justified. Yes, it's okay. It's okay, Mr. Jeffrey. That's all about Mr. Jeffrey.
That's all. That's all I got.
Okay, thank you so much. So cases are adjourned to a date to be communicated to counsel for judgment via Zoom.
The court.
Yeah,
As the court, please.
Thank you. Aja, which one again?
Hello. Hello. Hello.
Hello? My
Aja.
lord.
Yes, Aja.
Sir, we have Otis McLister, Olagu, and we
Okay.
have, I don't know whether Akinjide, Akinlabi, whether there's anybody representing him.
I also don't know.
But I
My
believe
lord,
the
defense counsel is here, my lord.
Irrespective of
okay.
yes.
The Akinjide Akinlabi
09/2021, my lord.
Okay, what about the claimant's counsel?
It's late.
Okay, and is the claimant in court?
No, my
No.
lord. But the claimant's counsel filed his final written address before he passed away, my lord.
So what do you do?
My lord, I was going to humbly request the court to rely on Order 38, Rule 3, Sub 3, my lord, so that his final written address can be adopted.
Yes, but what about the presence of the claimant?
But his phone number, I couldn't reach him through his phone number. I sent him an email. Up to now, he's yet to respond.
Okay.
And the defender gave me a number that I should contact a lady that was that took over from the late counsel. Didn't know anything about the fact that she would call the wife and ask. So that's where we have, my lord.
The defendant counsel gave you the number of somebody else.
Yes, of a lady that is being majority of the late counsel's matter.
Did you get her?
Yes, I gave it. I even sent her the.
The link.
Yes, my lord.
Okay.
So maybe because it's like the claim and the defendant counsel is in diaspora, so maybe we should just do it so that he can be on his way then. The defendant counsel.
Yes, okay, he's joining from overseas.
Yes, my lord.
Yes, my lord.
Okay. So Ajay, what were you suggesting? You have sent the link to the counsel that was said to have taken over.
We do. Yes, my lord.
But she didn't respond, but
she saw it. We talked after.
Okay, she saw it.
But she said she doesn't have the details of the file. Maybe that's why she did not join.
Okay. So what do you do now, Aja?
We adopt it, my lord. Since the final written address is there.
Okay. Yes, parties absent, yes, and
yes, my lord.
Haja, when you sent her the link, did she call you?
Yes, my lord.
Okay.
I can even text her now. I ask why
Okay.
she did not join. Let me try her.
Okay, yes, counsel for the defendant. Yes, appearance.
If it pleases the court, Baba Jimmy Ayorinde.
Baba.
Jimmy, Babajimi.
Yes.
Ayorinde is Ayorinde.
Yes, for
If
the
it for the defendants, my lord, I appear with my learned friend O
yes.
Ibabuchi. Ibabuchi is spelled IBEABUC.
IBEA.
Yes, my lord. BUCHI.
BUCHI. Yes.
Yes. Our humble appearance is for the defendants, my lord.
Yes.
Yes. My lord, the matter is scheduled for adoption of final written addresses. However, my lord, we have a housekeeping application. We filed our final written address out of time, and accordingly, we have filed a motion dated 15th February 2023, which seeks to regularize our final written address, my lord. Subject to your lordship's kind permission, may I move in terms of that motion so as not to waste time?
It's file on what? The motion?
It's the date on it is 16th of January 2023, but it was filed on 15th February 2023, my lord.
Okay.
Israel. Good. Sorry to bother you. This thing is not showing me clearly again. This is where I'm supposed to be. Is it sure? Is it okay? Okay.
So we move in terms.
I move in terms of the motion, my lord.
Okay.
My lord, may I also just ask that my lord should also regularize the claimant's final written address, which was filed in response to the address that my lord is just regularizing. Their own final written address is dated 9th May 2023, my lord. So that all the addresses will be deemed as properly filed today, my lord. We're grateful.
So defendant's defendant's application for extension of time to file its final written address filed on the 15th of February 2025 is granted as prayed. Consequent upon that, claimant's final written address is also deemed as properly filed and served.
As the court pleases, we're grateful, my lord.
Yes, Mr. Ayorendes.
Yes, my lord. Our final written address, my lord, was filed on the 15th of February 2023.
Yes.
And it's also dated the same date, my lord.
Yes.
My lord, we wish to adopt all the arguments contained in the final written address as our arguments.
Okay, did you file any reply?
No reply, my lord.
Okay.
My lord, we adopt all the arguments in that document as our arguments in this case, and we urge your lordship to dismiss the claimant's suit.
Okay.
My lord, will also be relying on Order 38, Rule 3, Sub 3, my lord, of the rules of this honorable court.
We also wish to rely on Order
38, Rule 3.
Yes.
Sub Rule 3, my lord, of the
Yes.
rules of the court. And we urge your lordship to deem the final written address of the claimant as having been adopted.
Okay.
We're grateful.
My lord.
Mm-hmm.
She said she's trying to join, but the network, maybe where she is, the network is not good. That's why.
Okay. Okay. So, by virtue of Order 38 Rule 3, Sub-Rule 3 of the rules of this court, since the Claimants Council has been duly served with the Zoom link respect of today's proceedings, Claimant's final written address is deemed adopted. Meanwhile, cases are adjourned to a date to be communicated to counsel for judgment via Zoom.
We are grateful, my lord, as the clock pleases.
Thank you. Okay. Thank you, Mr. Ayorinde.
We are grateful, my lord.
Thank you. Is this Japa something? Mr. Ayorinde?
Not at all, my lord. It's just a short trip. Unfortunately, when the hearing notice came, I was already out of town, my lord. So I didn't have my robes or anything with me, my lord.
Okay. No, I thought it's Japa that took you.
Not at all, sir. I'll be back soon.
Okay, please do.
I'm grateful for your lordship's indulgence, sir.
There is still hope in the country now. This will change for the
plenty of hope, sir. There's plenty of hope. Yes, sir.
Thank you so much.
Thank you, my lord. Bye-bye, sir.
Okay, bye. Thank you. Yes. Aja.
Yes, my lord.
Which one again? Is it Ghanaian? Okay, Ghanaian or Paul Agu? Which one is? I can see that Mr. Samuel Olusegun.
Ghanaians can come first because it's 116. While Paul is 534. So Ghanaians first.
Okay.
Okay.
Yes. Yes.
Is the claimant online? Mrs. Galia Takapo. I don't know.
Maybe she's the one. But you are muted.
Yes, my lord.
Okay. Present, defendant absent. Yes, appearance. Mr. Samuel. Still Mr. Samuel. Mr. Olusegun, we can't hear you. We can't hear you.
My colleagues. Okay, my lord, can you hear me now?
Yes, we can hear you now. You are for the claimant.
Yes, I'm hearing with me, sir. Awokobe. My colleagues. Awokobe. Awokobe is spelled A-V-W-O-B-O.
Is it A-B?
A-B. B-I-O-A. A-B.
Okay. A-B-U.
A-V-W-O-B-O-B-E.
ABWO OBG. Yes. Abu Obe. Okay. For the claimant. Thank you. Yes.
May my noble Lord be pleased.
Yes.
My Lord, sir.
Yes. Good.
Okay.
Good.
With greatest respect to your Lordship, sir. My name is O.O. My name is O.O. Adeleye. O.O. Adeleye.
Yes.
My Lord, I appear with my learned friends. Chukwudi Una. Chukwudi Una Esquire.
Yes.
Oluwaseyi Adegbesan Esquire.
Oluwaseyi
Adegbesan Esquire.
Adegbesan
Esquire.
Yes.
And my Lord, Omotoyosi Awolesi. Omotoyosi.
Yes.
Omotoyosi, my Lord.
Okay, SIS.
Yes, sir. My Lord. Awolesi. AWOLESI.
Yes, Awolesi.
Yes, my Lord. Our humble appearance is for the defendants, my Lord. Defendants.
So each of the defendants has its counsel.
No, it's a joint representation, sir. Two law firms, joint representation, sir.
I know. Thank you. Yes, Mr. Dele.
Yes, my Lord. The matter today is for adoption of final written address of parties. My Lord, we however have house cleaning applications to take, sir.
Yes.
In respect of the reply on point of law, sir.
Okay.
My Lord, I will identify two applications. We intend to discontinue with one because it was filed out of the abundance of caution. It wasn't necessary to file the application.
Yes.
My Lord, that application is the one on notice dated 19th day of February 2024.
Okay.
To extend time within which the defendant is to file their final written address.
19th of February 2020.
2024, my Lord.
24.
Yes, my Lord. It was seeking to regularize the final written address, which was filed within time, my Lord. It was filed out of the abundance of caution.
Is that one that you want to withdraw?
Well, I want to withdraw the application, sir.
Okay.
The defendant final written address was filed within time, my Lord.
Okay.
Yes, sir. It was filed within 21 days of the last hearing. My Lord, I seek to withdraw the application, sir, so that the file of my Lord can be tidy.
Okay. 19th of February 2024.
Yes, sir. Seeking to regularize the defendant final written address.
Okay.
My Lord, it was filed on the 4th day of March 2024. It is dated 19th February 2024, but filed 4th March 2024.
Okay, okay. Yes. Mr. Sam, any objection to the withdrawal?
Yes, I have no objection.
Eh?
I have no objection to it, sir.
Okay. Mr. Adele is dated 19th
of February 2024, but filed 4th March 2024.
Okay. So defendant's application dated 19th of February 2024, but filed on the 4th of March 2024, having been withdrawn, is hereby struck out.
As please.
Yes, Mr. Adele.
Release me now with the motion on notice dated 2nd April 2024, my lord.
Yes.
My lord, that motion is seeking to regularize.
File when?
Was filed same day, my lord.
Okay. Is dated and filed on 2nd April 2024.
Yes, my lord.
It's 6.
My lord, seeks to regularize the defendant's reply on point of law.
Okay.
Which was filed out of time, my lord.
Yes.
With the kind permission of your lordship, sir.
Yes.
And subject to what my learned friend has to say, we seek to move that application, sir.
Okay. Mr. Sam, no objection.
My lord, I have no objections.
Thank you.
My lord, I crave the indulgence of court to move in terms, sir.
Thank you.
As court, please.
So the defendant's application for extension of time to file its reply to the claimant's notice of claimant's final written address dated and filed on the 2nd of April 2024 is granted as spread.
As court, please.
Yes, Mr.
Yes, my lord. Yes, my lord. We'll proceed straight to adopt our written address. My lord, the defendant's final written address, my lord.
Yes.
Is dated the 31st day of January 2024.
Yes.
Filed on the 16th day of February 2024, my lord.
Okay.
My lord, we adopt all the argument canvassed in the said final address in urging your lordship, sir.
Okay, then the reply is dated when it's filed.
My lord, the reply, yes, my lord, the reply on point of law is dated the 22nd day of March 2024, my lord. Filed on the 2nd day of April 2024.
Yes.
And deemed properly filed today, 25th day of July 2025.
Yes.
My lord, we adopt the argument canvas in both the final written address as well as the reply on point of law, sir.
Yes.
In urging your lordship, sir, to dismiss in its entirety the case of the claimant as unmeritorious and the award of costs against the claimants in favor of each of the defendants, my lord.
Yes.
We commend to your lordship all the argument canvas, and there's nothing more to add, sir. My lord, we are grateful.
Thank you, Mr. Adele. Thank you.
Yes.
Mr. Samuel.
Thank you very much, sir. My lord, we also filed our final written address.
Yes.
Claimant's final written address.
Yes.
And it is dated the 4th of March 2024.
Yes.
filed on the 4th of March, 2024.
Yes.
Was filed on the 4th of March, 2024.
Yes.
My Lord, we commend all these arguments to your Lordship, and we
Yes.
seek to adopt this final written address
Yes.
as the arguments of the claimant in support of this action. And we respectfully urge your Lordship to grant all the reliefs sought by the claimant in this action.
Yes.
My Lord, the written address is detailed and is straightforward. The facts are before the court. The law is the bosom of the court. And the only thing that is looked up to my Lord for at this stage is justice in this matter. And we respectfully urge your Lordship to do justice and grant all our needs. Without more.
Thank you. Thank you, Mr. Sam.
Well, this thing can't go for anything. Instead of being straight. And then if I talk, I hope this thing, they will hear me. Okay.
We're even hearing you.
Thank you, my Lord. Thank you, my Lord. So good.
All are hearing you, sir.
So, Mr. Sam and Mr. Adele,
Yes,
cases adjourned to a date to be communicated to you via Zoom for judgment. I thank you so much.
Answer, please. My Lord, we are indeed very grateful, sir.
Thank
We
you,
seek your
Mr.
Lordship's permission to exit the platform, sir.
Granted. Thank you.
As grateful, my Lord.
Thank you. Yes, Mr. Paul Abuan Otis.
Yes, sir.
Yes. Yes.
I first of all crave the indulgence of the court to allow me to appear in Mufti. I didn't
It's
properly
okay. It's
dress.
okay. It's okay. It's okay.
I'm so grateful, sir. My name is Louis N. Oji.
Okay. The claimant is not in court.
It's not in court, sir. He's absent,
Okay.
unavoidably absent. And we plead for the understanding of the court.
Okay. Parties absent.
Yes, sir.
Mr. Lois N. Oji.
Yes, sir, for the claimant.
Oji, yes.
Yes, sir, for the claimant.
Yes. Yes.
Please, my lord.
Okay, yes. Is that Chime or what? Or who? Yes.
My lord, my name is V.N. Nwobodo.
Okay.
V.N. Nwobodo.
Okay. V.N.
Nwobodo, my lord.
Nwobodo, yes.
For the defendant.
You are alone?
Yes, my lord, I am. Yes, my lord. Good to see my lord's face again.
Thank you. Good to see you again.
Thank you, my lord.
Mr. Nwobodo, is there any pending application?
My lord, there is none.
Okay, okay. Yes, Mr. Nwobodo, yes.
My lord, the defendant's final written address is dated 27th day of June, 2026.
Yes.
Same was filed the same day, my lord.
Okay. It's dated and filed
27th June, 2022.
Yes. Yes.
My lord, we adopt the said written address as the defendant's final written address in this suit. In urging this honorable court, my lord, to dismiss the claimant's claim.
Yes.
And grant the defendant's counterclaim, my lord.
Okay, you have a counterclaim.
Yes, my lord.
Is this on the customer giving credit to customers?
Giving credit above the
okay, above the limit.
Prescribed, yes, my lord.
Limit.
Yes, my lord.
But did the agreement between the parties say that whenever the claimant gave any credit to customer above the limit, he'll be liable?
Yes, my lord. It was provided in the agreement that there must be a limit to that, my lord, which the claimant exceeded.
But when he gave above the limit, is it provided that he'll be liable to pay the debt? Or
yes,
just
my lord.
Or just stated that he shouldn't give above the limit?
My lord, it was actually prescribed, and then even when he exceeded that, it was communicated to him by the defendant.
No, what I'm trying to say is that is it provided for in the handbook that when
yes,
the claimant gave the credit to the customers above that limit, he'll be
liable to the excess credit limit.
Okay.
Yes, my lord.
It's stated.
Yes, my lord.
Okay.
And then there was also a claim that he was employed from a certain period to a certain period, which the defendant is saying that at the time he was also claiming unpaid allowances for certain periods. He was not under the employment of the defendant, but under the employment of another company. My lord.
But he said it's the same that same company. Okay, that other company is also, is it a sister company or saying, or is being owned by by the same?
It's not though they are both the defendant and the company in question. We are subsidiaries of another company, my lord.
Okay.
Yes,
okay. 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 They are subsidiaries of another company.
Yes, my lord.
Okay.
They are subsidiaries of Impact Trading Nigeria Limited.
Okay. So you're only
the defendant here is standing on its own, my lord.
So you're only saying that his work in the other company
has nothing to do with the defendant, my lord.
Yes, and in the computation of his entitlement, it can stay there, cannot be counted.
Yes, my lord.
Okay. And this issue you are saying, you say he collected loan or what?
No, my lord.
You say he collected loan. The claimant collected loan.
No, my lord. I don't think there was an issue of loan.
Okay. It's okay. Maybe I'm mistaken.
It was the excess credit facility that he gave.
Okay. Only the excess facility. Okay.
Yes, my lord.
Okay. It's okay. Is that all, Mr.
My lord, we also filed a reply in front of law. I don't know if we adopt that before the claimant.
I asked whether you have a reply on counsel, but you said no.
No, what my lord asked was if there was a pending application.
Okay. Okay, so aside from the main written address, you also have filed a reply on the 1st of September, isn't it?
Yes, my lord.
Okay. We've also filed a reply on points of law on
Dated 22nd August 2022, but filed on 1st September, my lord.
Okay. 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 It's okay. Thank you, Mr. Mobodu. Mr. Oji.
Yes, sir.
Yes, Clement's
Written address, sir, is dated 20th of July 2022 and filed 21st of July 2022.
Okay.
Yes, sir. In the said address, sir.
Yes.
3 issues for determination were canvassed on behalf of the claimant.
Yes.
We adopt all the arguments in support of those issues as contained in the claimant's final written address as our argument in this matter.
Yes.
And we urge the court to grant all the reliefs contained in the claim, sir. I just need to say something, sir, that will further clarify this matter because of lapse of time.
Yes.
The 2 arguments that the defendant raised, which we equally countered in the final written address. Number 1, they said that he exceeded the credit limit that was given by the company to him.
Yes.
It is before the court that he didn't exceed any such credit limit, because in the schedule prepared by the defendant himself, it was evident that the 200,000 naira limit was not exceeded.
Okay.
That is number 1, sir.
How will the court know that it's exceeded or not?
It is they prepared a schedule, and there was cross-examination in relation to that dispelled every argument concerning that.
And is there any document presented before the court that this is the loan?
Yeah, they presented it. They prepared a schedule which they attached, containing the various amounts that they said the defendant gave out to people that is still outstanding. They prepared a schedule.
But there's no document showing that this is the actual amount given as credited by the claimant. This is the person that was given.
No, sir. No, sir. What happened is that schedule they brought is in favor of the claimant. He never exceeded, based on the document they brought, he never exceeded the 200,000 naira limit. And the only witness that they brought. Yes, sir.
Okay, I want to ask this question again.
Yes, sir.
What document is showing that this is the limit that the claimant shouldn't exceed in giving the credit?
There is no such document. It was only stated in their statement of defense.
Okay, that 200,000 naira is the claimant's limit.
Yes, sir. In terms of giving out credit to customers.
Yes,
my lord, there's a contract.
Let me land. Wait. Let me land. Can I land? Even at that, because the issue before the court did not turn around whether the defendant gave above the credit limit. What they said was that some amounts were outstanding and that it becomes personal debt to the claimant. that such monies that were outstanding were personal debts to the claimant. Meanwhile, there's admission by the only witness they brought that the claimant, before he finally exited from the defendant, took the auditor and the chief security officer to the market and showed them one by one. And they took the list of all the people that were owing before he finally exited. So that's the position, sir. Yes, sir.
Now, what I was trying to ask is, what document is indicating the credit limit of the value of the goods that the claimant should give?
My Lord, is for the defendant to answer.
My Lord, I think that is stated in the contract annex. And again,
which is exhibit what?
I'm trying to. My Lord, that is exhibit OMW2A and B.
Okay.
Contract annex, exhibit OMW2A and B.
Okay, contract annex.
Yes, my Lord.
The one that indicates the credit limit of the value to be given by
my Lord. Yes, my Lord.
And it's particular about the claimant, or it's just about his level?
About the claimant, my Lord.
Himself,
my Lord, and the credit limit allowed. And my Lord, there is also a one letter. That is exhibit OMW5.
Okay.
A one letter to the claimant when he exceeded the credit limit.
Okay. After he exceeded, you wrote him a one letter saying that
yes, my
this
Lord.
is what he did.
Yes, my Lord, and that is exhibit OMW5, my Lord.
Okay. Yes, Mr. Oji.
Yes, sir. My Lord, this argument had already been dispelled during trial because the schedule of outstanding sums that they claim that the defendant gave out as credit, none exceeded 200,000 naira. And it was admitted in evidence by the only witness, Mr. Nicholas Mwachuku. He admitted that he didn't exceed any credit limit. And finally, sir, just to put all the issues before the court, the issue of a defendant being employed by another company as against this thing does not arise. Why it does not arise was because this subsidiary company, Otis McAllister, the defendant here, and Cover Wine that they are talking about, that they claim the directors are the same building that they were working in, the same nature of business, the same schedule, nothing changed. Nothing changed. So it is.
Yeah, but they are saying that there are two different entities now, isn't it?
They are not two different entities, sir. They are not two different entities.
If they are the same company, is there anything before the court that will show that they are one and the same thing, Mr.?
They admitted in the court. They admitted in the open court. The evidence of the PW1, the claimant, was not challenged. When he answered under cross-examination that it is the same company, the same directors, the same place of business, the same type of business, and his own job, the same schedule of job.
There was no such admission, my Lord.
It is there. It is
there
there
was no such admission.
in cross-examination. My Lord will look at it. Don't worry, so that we don't join issues on that at this level.
Cross-examination of the claimant or of the defendant?
Cross-examination of the claimant.
Okay, under cross-examination, he affirmed that is that what you want to say?
That the companies are the same, the schedule of work the same, the nature of business the same, the director the same. So it's just a question of.
Okay, this is said by who, Mr.? It's said by the claimant.
By the claimant, yes, sir.
But there was no such admission by the defendant, my Lord.
Who worked with them for 13 years?
But okay, but Mr. Oji, if there are two companies.
Yes, sir.
And the claimant is trying to establish that the two companies are sister companies, they are subsidiary of another company, they are having same directors.
Yes,
Can
sir.
just avament of the claimant prove that?
As a couple is, my lord, we
There
even
is
made
there is nothing that the defendant brought in disproof of the position of the claimant.
But the
Nothing.
burden is that of the claimant to prove his case now. It's not for the defendant to start to.
Yes, my lord.
Even under cross-examination.
We also made reference to
Wait
the fact that
now,
the
my learned friend,
CSC
please,
certificate
can you wait?
would have also helped
Can you wait?
And
okay.
it wasn't pleaded before the court. And my lord, again, on the issue of
you tendered the certificate of incorporation of the
No,
my lord, we didn't do that. We only made reference to the fact that it wasn't pleaded, at least to establish that the two companies are the same, because the onus was on them to establish that the two companies are actually the same, my lord.
There was admission,
and my lord,
again,
my lord,
under cross-examination of the defendant that it is the same company.
Who admitted?
They apart from the avowment of the claimant under cross-examination, the defendant's only witness admitted that too. That everything they are doing is just about, well, it's known to them why they changed the name of the company after a while. While the defendant was still working with them under the same environment, the same house, the same distribution of wine, the same sales rep, everything. So our argument is that the defendant knows what he was doing when he changed his mind, and then they brought in another name as the name of the company. There was no termination letter. The ID card was not withdrawn. Everything was still intact. So it's just seamless transition. It was seamless. So for them to come and argue now that it was a different company, I think somebody is trying to be mischievous, and the law will not allow that.
Okay, Mr. Mobodu,
yes,
this is what DW once said on the cross-examination. He said, I don't know whether the claimant was sacked by Cover Wines Limited in 2015. The claimant took up another contract of employment with another subsidiary company in Petro Nigeria Limited. Yes, Cover Wines and the defendant are subsidiary of Impacto Nigeria Limited.
Trading. Yes, my lord, which I stated earlier.
Yes, Cover Wines Limited and the defendant are doing their separate businesses, but in the same compound. Is it Impacto or Impacto?
Impacto, my lord. Impacto.
Okay. Impacto Nigeria Limited was housing Cover Wines and the defendant. I would not know whether the claimant was doing the same job in the defendant company while he was with Cover Wines. I was not among those who calculated the disengagement entitlement of the claimant. We arrived at 3 million naira as the full and final entitlement of the claimant by exhibit OM2AB, given the credit to customers is not completely prohibited. Giving credit to customers without approval becomes a personal debt on the employee. It's not written in exhibits OMW1 and 2 that giving credit to customers without approval becomes a personal debt. In paragraph 50 of my deposition, none of the calculations from the balance of the debt is more than 200,000 naira. 200,000 naira. We deducted 700,000 naira from the claimant's entitlement. 563 was also deducted from the claimant's entitlement, apart from the 793,000 naira. It is on the basis of our calculation that we arrived at 510,000 naira. Our counterclaim, in our counterclaim, yes, the claimant and our chief security officer and our auditor went to the market and identified to them the customers that were owing the defendant. Commissions are paid to marketers under certain conditions. The financial controller called the claimant on phone to a meeting on his outstanding debt, and the issue of his contract of employment came up. We are entitled to our counterclaim. This is Mr. Ngobo. This is what the DW1 said.
Yes, my lord.
This is what the DW1 said. Yes. So according to the evidence of the DW1, from the calculation, the claimant did not even give the goods above the credit limit. He admitted, Mr. Mabodu.
Sir, my lord.
He said, yes, he said in paragraph 15 of my deposition, none of the calculations from the balance of the debt is more than 200,000 naira.
There are two different things, my lord. We are talking of a credit limit here. Even there was no issue as to whether he exceeded. It wasn't in dispute that he exceeded the credit limit. His only explanation was that the customers gave promissory notes to liquidate the debt, my lord. He didn't even deny that he exceeded the credit limit.
But what is paragraph 15 saying of his deposition? Mr. Obodu, is paragraph 15 is saying that the value of goods sold to customers beyond the approved credit limit and is still unrecovered is 793,000 naira as of 31st of August 2020. Particulars. Then there are, and this question was related to this paragraph 15 of the DW1's deposition. He said that from the calculations made in his paragraph 15, none of the calculations from the balance of the debt is more than 200,000. I don't understand. I don't understand this.
Can I answer, sir?
Yes.
The explanation, I put the question directly to him that
yes,
in this your calculation of the outstanding sum, that each entry you made in that place that has helped you to arrive at 700 and something thousand naira did not exceed the 200 naira credit limit that you said you should not exceed. Sir?
200,000 naira.
200,000 naira. And he said yes, that he did not admit. Even in the schedule that they brought, which they attached, there was no such a case of exceeding
but Mr. Oji, I thought the particulars itemized in paragraph 15.
Yes, sir.
You know, they are showing invoice, amount paid. Okay, the first name, number 2, invoice, number 3, amount paid, then number 3, debt. So I thought, what do you mean by saying that the, okay, like from the invoice,
yes, sir.
in the case of Alhaji Giwa, 399,000 naira, amount paid, 356,000 naira, then debt, 43,000 naira.
Yes, sir.
So where is the yes. Okay.
So what
okay, so it means it means from this 700 the total debt.
That's the total credit to customers, my lord.
Yes, is 793,000 naira.
Yes, my lord.
But individually.
Yes, sir.
But individually, it didn't exceed 200,000 naira.
At all. And the document is as to individual clients, individual customers, not some total, generally.
Yes.
What was prohibited is giving one person goods in excess of 200,000 naira.
200,000 naira, yes.
Yes, sir. That was what was stipulated. And he never exceeded that because he recovered all the money. The balances that were left were not up to 200,000 naira or in excess of it. So he didn't breach any of their rules.
Yes, Mr. Obodu, did you get it, Mr. Obodu?
Yes, my lord. Maybe when my lord takes time to also look at our listing, my lord, we have a clearer picture of that.
Okay. Yes, Mr. Oji, you are raising some points. You have raised one. What about the other three issues?
No, I've raised all the three. I've addressed all the three in our argument, because what we said is whether the defendant proved this counterclaim and set off in the matter. And our argument is that it wasn't proved. Then whether the claimant has proved his case against the defendant on preponderance of evidence, and we argued that he has done that based on all these arguments that we're even canvassing before the court now. Then the other one is whether the attitude of the defendant in substituting Exhibit PA1 and PA2 with Exhibit OM is a proper case where the Honorable Court can lift the veil of incorporation to discover that the defendants were running away from its obligation to the defendant, and to discover that both Cover Wine and the defendant have Mr. Dozier Udeze as managing director.
How can I lift the veil?
As you come, please. My lord, there's no dispute as to whether the two companies are separate companies.
They are the same.
They are clearly separate companies.
In the arguments that followed this thing, we stated expressly, sir, that the directors are the same business.
Okay, Mr. Oji.
Yes, sir.
You tendered the two employment contracts.
Exactly, sir.
We
tendered it, sir. We tendered it, and our argument, sir. The main crux of our argument.
No, what I want to ask is that if the claimant wants to establish the fact that the two companies are sister companies, they are the same, I thought that should have been done by presenting the incorporation documents from the CAC, isn't it?
It was admitted by the defendant, sir.
No, but it
was admitted.
But can somebody by oral evidence start to say that company A and B are sister companies, they are subsidiary of another company, isn't it? They are man and managed. They are. Can that be done by oral evidence, Mr. Oji?
In certain circumstances, it can be done, sir, because there's no dispute there's no dispute. The argument before the court was that in the first company, sir,
if there's no dispute, Mr. Oji, if there's no dispute, Mr. Oji, if there's no dispute, why should the claimant be given two separate employment letters?
No, the other one subsided. That was why our argument is that when he left Cover Wine, that he wasn't sacked. His ID card was not recovered. Nothing was recovered from him. He just transited.
And was given another employment letter.
Separate from the previous one.
Mr. Oji was given another employment letter.
Yes, sir.
Why?
He was given another employment letter.
Is that second employment
in respect of
is that second employment letter then that this is a continuation of your previous employment? Mr. Oji, the second employment letter.
Depending on the circumstances, sir. Because if he had committed when this thing was happening, what I would have told him is, let them write in that same employment letter that is a continuation.
But they didn't do that. They didn't do that, isn't it?
Already come up before he consulted me. So my own understanding then was that since it is the same directors, the same company, the same building, the same type of business, his role did not change. He was still the marketing officer. They never sacked him. There was nothing to show that he was asked to go. We have finished with you. It was the convenience the convenience of the defendant now, probably with the people he's doing business with, he understands, he knows that. That was why they now came up with.
And he didn't join that former company, isn't he? He didn't join them.
No, why we our mind went to that thing, but our conclusion was that it is the same company, it is the same business, it is the same directors, and the managing director did not change.
And they're denying it.
They didn't deny it. They admitted that Mr. Dozier Udeze is the managing director of both Cover Wine and the defendant. It was admitted.
And is the managing director a party in this case?
Sir?
Is the MD a party to this case?
No, my
It's not a party. It's not a party.
So, since it's not a party, why should we begin to, to say something that will, isn't it, Mr. Yeah. Because the burden still remains on the claimant to prove his case, to prove all those things that he has alleged.
Yes, sir.
That the that the managing director are the same. The two companies are owned by socialist companies of another company. I think there should be a document stating that.
Yes, my lord.
Okay.
If my lord looks at this matter, I find it difficult to understand how somebody that worked for you for 13 years, from you said that his entitlement is 3,000 naira. 3,000 naira after 13 years.
3,000.
That was what they said, and they admitted it.
No,
3,000 naira.
That was after deduction, isn't it?
Sir?
My lord, even after deduction, my lord, the claimant is the one indebted. The claimant is even the one indebted to the defendant, my lord, and
don't worry, the court will give judgment now.
That informed our counter claim.
The court will give judgment. When the court gives judgment, we know who is going who.
Okay, yes, thank you so much, Mr. Oja and Mr.
Thank you for your time. We appreciate you, sir. Yes, sir.
Thank you so much.
Thank you, my lord. I hope to see my lord in Lagos again.
Lagos is it's not easy. Yes, the cases are so much there.
Are you enjoying Uyo, my lord?
Yes, Uyo is calm, is quiet. No,
and the burden is less too.
Yes, it's less. It's less. The cases are manageable. But Lagos, I've carried more than 70 cases for adoption.
Honestly,
70 cases.
It's not easy. It's not easy.
It's not, but Uyo is calm, is quiet. From my residence to the court, just 5-10 minutes, you get there. but in Lagos, I was coming to office from Sengotodo. So sometimes I will spend 2-3 hours.
Hours in the hold up, burning fuel.
Yes.
The time that would have utilized to do good work will be spent on the hold up.
Really.
It's unfortunate.
It is so, but we thank God for that. It's an experience.
Yes, sir. Yes, sir.
It's an experience.
Thank you, sir.
All right, Mr. Oji and Mr. Omobodo, thank you so much. Thank you so much. I appreciate you. Thank you.
All right.
Thank you.
Wishing you a happy weekend in advance.
Yes, I wish you the same, sir.
Thank you. And happy court vacation.
Thank you, my lord. Same to you.
Yes, sir.
Thank you. So we'll send the Zoom link to when the email is ready.
As God please.
Okay, bye-bye. Thank you.
Thank you, sir. Bye-bye, sir.
Thank you.
Yes, sir.
These documents are not just for our office, it's for